Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Today we are discussing a case on the limitation period, particularly for the Consumer Protection Act. So previously I told you that as per section 24A of the 1986 Consumer Protection Act, so the NCDRC or SCDRC or district forum, they will not take up any case. After 2 years, they will take up the case only if it is filed within 2 years where the cause of action arises. This is more important. While disposing the case of Hyundai Motors India Limited versus Shailendra Bhatnagar 2022 in SLP number 4881 by 2022 on 20th April last month, two judges bench, Justice Vineet Sharan and Andrit Bose, held that the limitation period extends for the 2 years when the cause of action arises. And secondly, please remember, when the normally you will be under the impression that the case has to be filed within 2 years of the purchase. Please remember, it's not the purchase. It is 2 years from the date of cause of action, from the date. So if you go to the details of the case, it will be more easy for you to understand. So దీనిలోనే 24 ఇయర్లో అప్పుడు కూడా మీకు చెప్పడం జరిగింది. కాజ్ ఆఫ్ యాక్షన్ అంటే ఏమిటి? నాట్ ద పర్చేస్. సపోజ్ ఇఫ్ సమ్ యాక్సిడెంట్ టేక్స్ ప్లేస్, yes, from that date onwards, if you find that there is a defect, you can file it within 2 years. Please remember. అది కూడా కాకుండా సెక్షన్ 24 క్లాస్ 2లో ఏమిటి, ఏలో క్లాస్ 2లో ఏముంటుందంటే, you can file the case even after the limitation period, but the court will take it on file if you are able to show the sufficient reason or reasonable cause. Yes, limitation period accepted. So limitation period is not 100% criteria. Just like our pronote case, section 5 of the limitation act says when the pronote period, once it starts running, and after 3 years you cannot file any case. The limitation period is gone. But this is not that case. Right? Now our main point is whether the case can be filed within 2 years of the purchase of the vehicle or within 2 years from the date of accident. 100% within 2 years from the date of accident. So this is the law by the law of the land, the Supreme Court. Right. Now we will go to the brief facts of the case. Shailendra Bhatnagar, he was the complainant. Yes, he purchased a Hyundai Creta vehicle in the year 2015. On 21st August 2015, he purchased Hyundai Creta. Right? So he felt happy. The managing the showroom people said that it has got 2 front airbags. They will open whenever some hit takes place. They will deploy and they will rescue the driver. Like that they told, and he felt very happy. But incidentally, on 16/11/2017, please remember the date, 16/11/2017, that means after Sankranti festival, the day immediately after Sankranti festival, he was going on along with the father, sister and wife. He was going on Delhi Panipat highway. Incidentally, the car actually scratched another truck. Ultimately it meets an accident, and this man received head injuries. Wife is a small injury, but mother also injured badly because both of them were sitting in the front line. But the main problem is the airbags did not deploy. Simply to say, airbags did not open. This is the main problem. No doubt the case was registered. The people came there. The motor vehicle inspector also visited the spot. Ultimately, he filed a case of defect in the product. Under Consumer Protection Act. Yes, definitely. You all know that according to section 2 clause 7, he is a consumer because he purchased the vehicle for his own purpose, and he can claim the defect since the airbags did not open. No doubt. Do you mean to say that the company will keep quiet? They said that they have done some technical examination, ultimately came to know that the vehicle scratched from that side. Suppose if there is a head-on collision, if there is a vehicle directly comes into contact, then the airbags will open. But if it is from the side, airbags will not open or something like that. They have argued. Ultimately, the district forum was convinced with the argument of our man Shailendra Bhatnagar. They have awarded 2 lakhs compensation extra and other things. Now aggrieved by this, Hyundai company ultimately they have appealed from the National Commission. National Commission also dismissed their appeal. Ultimately the matter came to the Supreme Court. Here the main point is they have taken up this point. So this complaint was not filed in time. Limitation period is over. So as per this, so now they say that limitation period, section 24A, they have discussed in detail, and of course that's one part. As far as the second part is concerned, so the Supreme Court relied on Sale of Goods Act 1930, right? So the short brief facts of this case I am going to read for your convenience again. Car purchased in the year 2015, right? 2017, when car met with an accident, it was found that the airbags did not open or did not deploy, right? Whether the period of limitation for filing a consumer complaint commences from the date of purchase and not from the date of accident. So whether the complaint is time barred. So the Supreme Court replied, no. Vehicles are goods. Vehicles are goods within the meaning of section 2 clause 7 of the Sale of Goods Act 1930. What is section 2 clause 7 of Consumer Protection Act? It defines the consumer. Here goods as per section 2 clause 7 say that they carry implied condition of fitness. The fitness should be there till the disposal of the vehicle. 15 years. Yes. In this case, the safety feature of the vehicle fell short of the required quality of fitness. Therefore, definitely it is a defect in the product. So, consumer has relied on the safety features of the vehicle projected by the manufacturer. Therefore, he has spent more money and purchased the same. Therefore, please remember the limitation period began from the day of the defect surfaced, and there was no way by which the defect could be known prior to the accident. Is it? So accident అయితే కానీ ఎయిర్ బ్యాగ్స్ ఓపెన్ తెలియదు కానీ మామూలుగా తెలియదు కదా మనకు. మా కార్లో కూడా ఉంది ఎయిర్ బ్యాగ్ అని రాసి ఉంటుంది. ఓకే, వీ విల్ బి అండర్ ద ఇంప్రెషన్ దట్ ఈస్ వర్కింగ్. So definitely Supreme Court has come to the rescue of Shailendra Bhatnagar, and they did not entertain the appeal filed by Hyundai Motors. Very good judgment. Please read it and enrich your legal knowledge. Thank you very much.